Hello, hello, hello. Good afternoon. I would like to welcome you to a fantastic webinar today. The Cannabis Intellectual Property After Rescheduling. This is hosted by the City of Los Angeles Department of Cannabis Regulation. And my name is Dale Sky Jones. I am CEO and Executive Chancellor at Amsterdam University, the first and longest running training for the cannabis industry in the world. And I'm excited to be your moderator today. We are here because the Department of Cannabis Regulation has provided the Business, Licensing, and Compliance Assistance, or BLC program, to assist equity entrepreneurs in the City of Los Angeles when obtaining a commercial cannabis license and operating a successful cannabis business. Please visit cannabis.lacity.gov for more announcements on the ever-improving BLC program. You will also find more and new live webinars with different subjects and subject matter experts, as well as checklists, worksheets, and other management tools that you can download and use yourself, as well as links for accessing expert consultants in the BLC coaching program that connects applicants with seasoned cannabis subject matter experts. And we are dropping a link in the chat now for you to sign up for these amazing coaching services. You can also find self-directed online education on important topics related to running a successful cannabis business through the BLC's Learning Management System, which is usually called an LMS. Now, as part of the city's social equity program, DCR has launched this BLC LMS portal where you can access recorded webinars, online courses, and digital resources made especially for social equity applicants and licensees. And I do highly recommend that you take this course and explore the LMS if you have not done so already. And so before we get started, I just want to make sure we take a moment to review some housekeeping rules. Please note that this webinar is being recorded and can be viewed after the editing process on DCR's website in the LMS I just mentioned. You will be muted with cameras off for the duration of the webinar. This means that your camera and audio functions will not be available during the session. However, you should be able to hear and see all the experts. Now, please use caution if you do share any personal information. This is a public forum, and we want to keep the questions focused on today's topic. Also, please ask your questions about today's subject in the Q&A box. We are gathering and responding to your questions throughout the presentation, and we have a dedicated special Q&A session with two IP, intellectual property attorneys today. So please make sure you drop all your questions in, and it may be one that we have ready to answer, and if not, I'll make sure that we get to it. You are encouraged to utilize the Q&A box at the bottom panel of your Zoom screen. And you can use, like I said, that Q&A box for your questions. Everyone can see the answer to your question. Please do ask it. If you've got this question, it's likely that other people do as well. So please don't be shy. Finally, please note that today's content was not created by the Department of Cannabis Regulation or the City of Los Angeles. And this is for informational purposes only, even though they're both IP attorneys, they are not your attorneys. This information is subject to change and does not replace or supersede the Los Angeles Municipal Code, nor constitute legal advice. If you have specific questions outside of today's topic, please call 213-978-0738 during business hours, Monday through Thursday, 10 to 4, to speak with your DCR representative. Now, like I said, today's webinar is slightly different. And while there's a short lecture portion at the beginning, you are encouraged to be a part of this webinar and ask your questions. This is really just dedicated to answering the what ifs, and it is changing every day, including even today and tomorrow, this week. There are new announcements coming out all the time. And so this is one of those moments where understanding what is happening and realizing that you may be able to help shape the way the future falls out. So it is my esteemed pleasure to introduce to you today our subject matter experts, Mr. Luke Zimmerman and Dr. Dale Hunt. Luke Zimmerman, Esquire, and LLM, that's a Master of Laws twice over. He is the founding and principal of the Law Office of Luke S. Zimmerman, APC, and Luke obtained his undergraduate degree in philosophy from the University of Oregon at Eugene, then graduated from Thomas Jefferson School of Law in San Diego, California. His interests in international trade and investment law led him to the Netherlands, where he obtained his first Master's of Law from the University of Amsterdam. The focus of his master's thesis was the effect of bilateral trade agreements on the harmonization of intellectual property standards. His experiences living in Amsterdam and observations of the paradigm shift surrounding cannabis led Luke to believe that the end of cannabis prohibition would be the future of the United States. Based on this idea, Luke formed the Law Office of Luke S. Zimmerman, APC, where he assists entrepreneurs in the emerging cannabis industry and helps them protect their intellectual property. A core mission of the Law Office of Luke S. Zimmerman is drug policy reform, which is why Luke volunteers on the Clemency Project 2014, and Luke currently splits his time working with clients in California, as well as nationally on trademark issues. Luke is also certified by Oaksterdam University in both beginner and advanced courses and has been teaching with us for 7 years now, I believe. And I'd also like to welcome Mr. Dale Hunt. Dr. Dale has extensive experience with patent protections with a technical emphasis in life sciences, environmental technology, materials and manufacturing, medical devices and diagnostics, as well as plants. And Dr. Hunt has also experience with patent portfolio management and strategy advice, international intellectual property matters, right to practice, and product launch opinions, as well as intellectual property due diligence and licensing. Dr. Hunt completed degrees in botany, bachelor's, and genetics, MS, at Brigham Young University. Wow, master's there too. Cellular and molecular biology was your PhD in UC San Diego, and your Juris Doctorate, JD, that's law degree at UC Berkeley. And in addition to his diverse patent practice as described, he has also worked his entire career helping clients protect and commercialize their proprietary plant varieties in the US and over 20 foreign countries. Dr. Hunt has been a partner in several national law firms before founding Hunt IP Law, which some of you may also know as Plant and Planet Law Firm, in 2019. So you've got two of the smartest individuals on the planet on this issue in this webinar today. And please help me welcome both Luke and Dr. Dale. Thank you so much. Also, I just realized that I failed to move my own slides. So here is Luke Zimmerman as I do the intro, and Dale Hunt. Welcome today to Los Angeles. Good to have you.
Thanks for having us.
Thank you.
Now, I'd like to remind our audience that we recently did another webinar on cannabis rescheduling. And so much of what we're going to dive into today, some of the basis of that, if you're saying, wait, what? We're going to refer you back to this other webinar. Today, we are talking about cannabis rescheduling, as well as FDA approval, intellectual property, Schedule 1 versus Schedule 3, and what changes and shifts, as well as the nuance of how state legal full plant cannabis operations are going to be treated versus the FDA process and pharmaceutical companies. And so we're just going to kind of touch on a few of the comparisons and contrasts there. And then we get into our fun Q&A with Luke and Dale. And Dale. Two Dales and a Luke. Here we go. All right. So your quick reminder about cannabis rescheduling. It's important to remember that nothing has happened yet. We've had now not one, but two announcements from two different presidents that we have had a president ask the process start with the FDA and Health and Human Services to review how to move cannabis. This is a very extensive process, and if they don't take their time, it's going to be subject to lawsuits and potentially being overturned. And so, unfortunately, as much as the president would like to just stroke of a pen executive order this, it's actually only Congress that can make that change without having to go through all of these extensive review processes, public process, public input periods. The other question is whether or not all of those things that have already happened under the previous administration are going to be accepted under the current process. I'd also like to quickly remind everyone the definitions of marijuana, aka cannabis, versus hemp, and the Delta 9 loophole that is likely closing this November, which is just a hop, skip, and a jump. We're going to sneeze, and November is going to be upon us. So anything that is hemp derived has to be very specifically underneath the 0.3% THC, and the federal budget bill that removes THC, a loophole that happens in 2026, is about to make it nearly impossible for a lot of the companies that have been commonly competing against state legal cannabis businesses through that loophole. Now, whether or not something changes between now and then, there are a lot of lobbyists in Washington right now working on making that happen. And once again, as always, the question is not if, but who will be allowed to participate in that process, and when that might happen. So CBD and hemp were, or CBD derived from hemp and hemp were both descheduled in the 2018 Farm Bill fully, which is what created that loophole in the first place. And so anything that is cannabis derived or marijuana derived, as the federal government recognizes it, we are looking at Schedule 1. And the question is when cannabis, marijuana is rescheduled, will that only refer to the pharmaceuticalized products, or will we also enjoy elimination from the 280E rule, for instance, on taxation, as well as safer banking? Even with rescheduling, we will still need a Safer Banking Act. There will still need to be more protections in place. And that's part of why we want to make sure that you're educated on some of these details so that you know what you're asking for with both local, state, and federal government. And make no mistake, your local government holds a lot of sway with the state, which holds a lot of sway in this United States. And so legal interpretations are really going to matter. The biggest change is to participate in any product that is Schedule 3. That patient will still need a doctor's visit to get a prescription, not a recommendation, a prescription. Recommendation will no longer suffice to qualify a person for reimbursement through this. It's not the FDA that reimburses, but through this HHS process and the FDA process to be able to receive the $500 per year of reimbursements for hemp-derived CBD full spectrum products. Friendly reminder, there's no medical defense for violations of the Controlled Substances Act, which is what determines scheduling. And so if you are not following the FDA process, that approval process, you are still considered violating the Controlled Substances Act and the federal law. And this is part of the interpretations that we're going to unpack here soon. The federal government is still going to consider what we do in state legal businesses to be the uncontrolled production and possession of a scheduled drug, which is a federal crime. Fun facts. All right, so we covered this last webinar, what processes the doctors and patients, manufacturers of these cannabis products will need to consider if we move to Schedule 3. Today, we're about to dive into the process producers that will have to undergo for the drug or the substance itself to become FDA approved. And so I'm going to turn this over to Dale Hunt to break down this rather complicated process. Go ahead, Dale.
Yeah, and I'm going to go fast through this because I think the main message is that this is an incredibly complex and expensive process that is almost exclusively the province of Big Pharma, unfortunately. But when you hear about rescheduling to Schedule 3, you think, oh, great. Okay, this isn't going to be illegal anymore. That's fantastic. What is shifting from, though, is from being outright illegal to being so highly regulated that the regulations, the difference is maybe more theoretical than having any beneficial practical effect, other than the collateral things like possibly like the tax issues and so on. So you would either have to put a new cannabis medicine under Schedule 3 would either have to be like run like any other single molecule drug, and we've got some slides for that, or it would have to be considered generally regarded as safe. It would have to be recognized generally on the GRAS list, generally recognized as safe. Now, what's interesting about that is that GRAS was originally a list that reflected long historical human use of certain things like citric acid, sodium chloride, things that everybody knew was present in their food and had very either minimal or no effects, or they're very well known. And so they were generally recognized as safe. What's happened in the last many years, though, is that there's been some laxity on the part of the FDA in letting um, people who make food products or supplements just put things on the GRAS list themselves without a lot of review. The FDA is pushing back on that now, and they are probably in a rulemaking process that is very likely to clamp down on how liberally one can unilaterally put something on the GRAS list. So it might be that that's an avenue to explore, but it's likely going to be more complicated than it's been in the past. And essentially, what you have to do is you have to say, this is so well known and it's been around for so long and in human use for so long that most experts, most people would recognize that this ingredient is safe. I think we can go to the next slide. So this is way more complicated than we want to dive into very much. But basically, this is an overview of the process of the FDA approval process. So you develop a drug, you do some animal testing, you assess how safe it is, how safe and effective it appears to be in animals, and then you file an investigational new drug application, which is that step 2 there. And in the investigational new drug application, you make a case for why this should be a new drug. And during phase 1, you test basically safety on a small number of participants, and it makes sense to test safety on a small number of participants. And as long as you don't have any significant safety concerns emerge from that, then you can go to a phase 2, which is a lot more participants. And then they're looking closely at safety and efficacy. And the way they look at efficacy is usually with some kind of a dose response analysis that is based on the animal testing. And if they get through phase 2 so that it looks like it's safe and it looks like it's effective, and they determine the right dose, et cetera, then they can move into phase 3, and then they test it with many patients to make sure that any even statistically rare side effects can be identified, et cetera. Now, I think we can move to the next slide. What is complicated about this is that it takes so long, so much money to get through this. And once you've gone through all of this, then you get the drug approval. Now, I've had clients in the biotech space that went through this. They had the owner of the company believed in it so much that he kept pouring his money in. He was a billionaire. He kept pouring his money into the FDA process on something he really believed in. And after many rejections, they finally made it through. The company was publicly traded. The stock kept falling. He kept pouring. I think he put in over $1 billion of his own money. And by the time they got through that process, then they still had to market it. They had to get general acceptance of this drug, and the drug fell on its face in the marketing phase. So even though they finally, after more than a decade, got through this process, they still didn't really even recoup their investment in the FDA review process. So this is, I think this is just a way of saying that Schedule 3 is not a panacea. It might be a step in the right direction, or it might even be a step in the wrong direction, because if everything has to go through this kind of a process, you can see how discouraging that would be. Now, fortunately, there are some alternatives. That it might be that the grass restrictions don't get any tougher, and that there might be certain products that could be put in under the grass onto the grass list, and therefore um, considered to be compliant with the Food and Drug Act. But in general, I think that the better solution, and this is something that Dale Sky Jones touched on in her previous review of the FDA process, um, is that descheduling is going to be much more beneficial to everyday cannabis operators than rescheduling. I think we can go to the next slide. So yeah, this is a good summary of the fact that a new drug, uh, getting a new drug through this process is extremely expensive and extremely time consuming. Um, in addition, I have a different concern. When I grew up, I didn't understand much about cannabis. I was this very sheltered boy growing up in Utah, and the only thing I knew was that one of my friends smoked every day. But so I recognized the smell and some of the effects, but I didn't know anything about the chemistry or anything like that. As I became later involved in the industry and with some science background, I came to understand that the plant is not a drug. I used to think that marijuana was a drug. And that's kind of how it's being treated with rescheduling, is marijuana is now a Schedule 3 drug. In fact, marijuana, or cannabis more generally, is a factory of a vast number of cannabinoids and terpenes and other products, any combination of which might have a great beneficial effect for a patient. Or you could isolate individual cannabinoids and individual terpenes. And when you do that, of course, you're losing the entourage effect, which is the combined effect of different components of the cannabis plant. So I think the most effective medicines derivable from the plant aren't going to be single molecules. They're going to be combinations. And so that's why this point that botanical cannabis does not really fit, because it's not a drug. It is a source of all kinds of beneficial things that we can then combine and benefit from, either in formulations or with plant breeding and selection. And just in my experience as an attorney, I've seen so many different strains or cultivars of marijuana that have such vastly different effects. So it's also really naive to classify the plant as a drug.
Yeah, and that's a really important point that I want to underline is those two slides that came straight from the FDA's website. If anybody wants to look for this themselves on that, normal process is for a new drug, and that is not this. And so let's unpack. There may be a couple different ways here that whole plant medicine may be utilized and applied and recognized and potentially reimbursed by the FDA, whether that is, currently the way it's being described is only hemp derived. And for California, as a legal cannabis company, you're not allowed to actually touch hemp until 2027. And so we have a very fine needle we have to thread here between our state law and our federal laws. And there are definitely things that we can do to prepare. And I suspect there are many things that you're already doing as a business owner that comply and comport. And what you're really missing is writing it down and having the ability to exhibit all of the things that you're doing in good manufacturing practices and ensuring that you're accessing your cannabis through somebody that utilizes good agricultural and collection practices, the GACP, that was also unpacked in the last webinar. So what
And
say you?
I'll just say one more thing about that. There is a process and a document released by the FDA for approving botanical medicines. It's 30 plus pages of detail. So way beyond the scope of this. But even then, it's very imprecise. There's no guarantee that complying with that will get it approved, and there's no requirement that you have to comply with that. They're basically saying, "Hey, give it a shot. Go ahead and submit something as a biological medicine, and we'll see how it goes." And because of the rigors of the FDA process, I'm afraid that that might be even more complicated rather than less complicated than the review of a single molecule drug. So again, I think the solution is going to be to recognize that the plant itself, in all of its different forms, is has great potential, but it's not dangerous in a way that, that there's this concept called LD50, which is the dose at which 50% of the people taking that dose would die. Lethal dose 50, that's what it is. And there's an LD50 for salt, there's an LD50 for caffeine. There is no LD50 for cannabis because the psychoactive molecules that affect the brain don't have receptors in the brain stem. And it's the receptors in the brain stem that make other things like cocaine or whatever shut down your brain function, the brainstem function that regulates your breathing and your heartbeat and so on. So there is no lethal dose, and certainly not encouraging people to overdose. But I think at some point when the science catches up with the policy, if it ever does, or when the policy catches up with the science, they will recognize that this is not something that should be regulated through a billion-dollar process. It's something that should have its own approach, and we're hoping that it'll get there.
Indeed, Dale, and multiple scientific reviews have indicated that that is exactly, it should be descheduled and should never have been scheduled in the first place. And that's not my opinion, although I happen to agree with it. That is the Schaefer Commission through Nixon. It is also the Judge Francis Young, the DEA administrative law judge that reviewed it in the late 80s as well. So yes, science versus politics. Luke, was there anything else that you wanted to mention before we moved to?
No, I think you guys did a wonderful job laying out the issues that we have. I think, if anything, I just also want to highlight, as we're talking about this, all these things are forward-looking statements in a way where even in the 5 minutes waiting to start this presentation, I saw a new article that there's already a lawsuit that has been filed that might have this entire thing get hemmed up, slowed down, or stop. So as we're talking about these things, I think it's also, when we're going to hit this in the section that I'm going to be talking about next, it's good to just prepare for what you have in front of you. It's good to think about the future, but don't start spending substantial amounts of money that these things are going to occur, or even in the form that they're being discussed, it's going to shake out in a certain way because it's still so underformed. Yeah, that's just one big thing I would highlight. I've been doing a lot of research in the last 48 hours about more recent comments that have been coming up. And if anything, to me, my intuition, for having worked in the legal side of cannabis now for almost 13 years, when you see stuff shifting this much, it's more of a hold your cards than start going full bore, unless you have bottomless resources and you're willing to take a really, say, sophisticated risk, which, yeah.
Which I also believe is known as a crapshoot in this industry. I don't know that there's any safe, sophisticated anything.
I don't think there's, safety is not part of that.
It's a good time to pour your energy into advocating for better policies than pouring your money into long-term planning, right?
Yeah, I would agree with that.
And thank you. That is why I wanted to have this webinar, because while it's not a good time for companies to spend a bunch of money on trying to do this or that, it is most important for you to show up and have your voice heard. Again, local, state, and especially federal, that this is the opportunity to sway the direction that this goes. And, just even looking around you at the other folks, whether they have power because they're voters or because they're community leaders or thought leaders, that having the conversations that need to be had, that you don't get left behind as these policies. I promise we have Pfizer lobbyists, we have hemp lobbyists, we have everybody but us in a lot of these rooms. And so it's super important that the voices that can be leveraged, again, including your local government, especially in Los Angeles, that we need to teach our leaders what to be asking for, while also girding ourselves for the predators that are going to come for us, looking to extract those dollar bills through fear. Because people are going to come try to say that all this stuff is happening and you need to give them money so that A, B, C, D. And these webinars are so that you know what's true, what's fact, what's fiction, what's false. And anyone selling you certainty is selling you a bag of bunk. There is no certainty. That's true. All right. So let's jump in, Luke.
Yeah. So talking about things that you can do now, I gave a presentation, I believe, to this group last year, I think, but we're going to highlight some of the information that I covered in the prior presentation. If you have been listening to the conversation up to this point and you've been hearing the word patent thrown around and you're like, I have no context what they're talking about, or I don't know what that is. It is a type of intellectual property. And I would say this is the big umbrella. When I use the phrase intellectual property, there's many different types of intellectual property. So patents are one of them, trademarks are another, copyright, trade secret. Patents are for things that are like an invention or a method or a formula, or in the case of a pharmaceutical drug, where trademarks are brands or source of origin indicators, where if you see a word, a logo or a slogan, when you associate that product with the company that created it. Copyrights are artistic works fixed in a tangible medium, ranging from music to movies to paintings to sculptures. And then trade secrets are formulas that give a competitive advantage in the commercial market that have been kept secret. Examples of that might be the herbs and the formulation of the herbs and spices for Kentucky Fried Chicken. For where we're at as an industry right now, all of these, especially if you're participating in the state legal process and you have a license, all of these touch your business probably in some way, shape, or form. You might not be pursuing innovation, so maybe you're not seeking to register a patent, but you're probably using some materials or some machines that have patents behind them. If you're running a business, you very likely have a brand, which would be your trademark. And then copyright applies to things like packaging for us, or website design, or maybe advertising. And then trade secrets, I mean, if you're an edible manufacturer or you're making concentrates, or even if you're a retailer and you have a confidential list of maybe customers, those are all potentially trade secrets. So intellectual property, if you're a business owner, touches your life and your business in some way, shape, or form. I think next slide. So key difference, especially because we've been talking about patents a lot today. The United States Patent and Trademark Office is the federal agency in the United States that has control and jurisdiction over granting patent rights and patent registration and federal trademarks. Both of them are through the USPTO. Patent law has a different set of requirements than trademark law, even though they're both at the same agency. So it's already been tested in court that you can receive patent protection for cannabis-related goods or cannabis-related methods or cannabis-related pharmaceutical drugs. Whereas with the trademark issue, there's a lawful use requirement in order to have a federally registered trademark, which prohibits, so if I want to file a trademark for retail services of cannabis, I can't do that at the federal level because it fails the lawful use requirement. Anything that's really plant touching directly for marijuana would not receive federal trademark protection. There is a different standard for hemp because hemp is currently federally legal, with the understanding that that might shift in November. So you could seek, at least as of right now, a federal trademark registration for hemp cigarettes. But if I filed an application for that contained 0.3% or less THC by dried biomass, But if I filed an application for marijuana cigarettes containing more than 0.3%, I would have that rejected just outright. So the USPTO, it's interesting because for having this split between patents and trademarks, having one side where you can even register, so patents come in three types: the utility patent, the design patent, and then the plant patent, which Dale is very versed in. And Dale has registered plenty of plant patents for different cannabis cultivars with the USPTO. So there's a pretty wide gap between patents and trademarks. Yeah, the other point for trademarks, historically, prior to the Lanham Act, most trademark issues were handled just at the state level. And that historically, if you look back to the Constitution explicitly addresses patents and copyrights, doesn't address trademarks. That came in much later. So what that allows for an opportunity for state operators is to seek trademark protection at the state level. And if you're, I mean, in California, especially, we at the start of 2018, we started accepting state level trademarks for cannabis related goods and services. So you can at least find some limited form of brand protection by using the stigmas between the two.
I think you're back now.
Oh no.
No, it was just super quick. If you could repeat your last sentence.
I think this highlights the major differences between patents and trademarks. And then next slide.
Perfect. All right. Thank you. All right. So we are going to jump into Q&A with Luke and Dale, our two favorite IP attorneys. And it is fascinating to me. You know, I learned the hard way. You have to use the right tool for the job. And that includes doctors and lawyers. You don't want a heart surgeon working on your brain, and vice versa. You don't want a divorce attorney working on your business license. It is fascinating how deeply differential intellectual property and protections is. Like, this one sliver of law, this nuance, is its own like of differences, and you two really encapsulate a large swath of that. But could each of you just kind of in under a minute, like, break down why the way that you two look at things are different, so that we can understand as we go into how you're looking at these different answers, the perspective that you're coming from.
I would never touch a patent, and I refer actually a significant amount of my work to Dale because I don't understand how they function. I have reviewed patent registrations, and it's so esoteric to me that trying to deduce both the science behind it and even just how the form is put together, I have a limited understanding of, almost purely from the academic sense. And it's the gulf between these two things, even though they're housed and the agency overlooking it is the same agency, they don't even overlap at the USPTO. Those are like really bifurcated. I have focused on source of origin indicators for the most part, with some copyright for my practice. And that is a whole world unto itself, both in prosecution, enforcement, standard, and qualification for getting the registration completed, let alone having it be valid in a way that it's enforceable. I think the way that you monetize trademarks or brands is just significantly, there's a similarity, but it's also significantly different than patents. So that would be why I don't touch patents, and I refer them to Dale.
And in a very similar fashion, I send out the trademark work. When I started my own firm, I thought, well, I should try to do anything that comes in the door. And then I realized pretty soon that I had very high standards and a lot of experience when it came to patents. And if I gave somebody advice, I didn't have any doubt that the advice I gave them was good advice and that the work I did was good work. when it came to trademarks or other things, I realized, okay, I don't want my reputation to be defined by how much I or little I know about trademarks. And so I learned pretty fast that to keep my reputation as a specialist who's very good at what he does, I needed to focus on doing the things I'm good at and that I was trained to do. And so, yeah, I send out my trademark work for similar reasons as Luke outlined. I think the other thing that is interesting about it is just that, as Luke said, even though it's one federal agency that handles both things, there's this, the patent side of that agency applies a completely different law in evaluating whether someone is entitled to the intellectual property rights they're seeking, and then the trademark side does. And so if I qualify for a patent, I can't go over to the other side of the office and say, hey, I got a patent, so I should also get a trademark. You'd be laughed out. The statutes that establish what the standards are for obtaining those two kinds of IP are just entirely different.
I also
And
want to highlight, as a tip of my hat to patents, like Dale having a background with plants where he understands plants, kind of like Dale Sky Jones said, you don't want a heart surgeon working on your brain or a brain surgeon working on your heart. Patents, and you think about them, I mean, running from mechanical engineering to bioscience to there's so much nuance that goes into science. So even oftentimes, if you're going to hire a patent attorney, you want to find someone who has the relevant background in science to understand the language. And this is one of the reasons why I have a ton of respect for Dale, where him working with plants, you're not going to find a lot of other attorneys that are practicing in the cannabis space who have a background like that and can actually understand the language, not just from how the industry and culture talks about the plant, but from the next step of this is scientifically how it applies. These are the legal standards, which really is the next part of the next step in evolution, especially if this is going to be descheduled, where it's like we need to understand the nuts and bolts of how this plant works and what it really is.
Thanks for saying that, Luke.
well said, well said. And it's super important for folks listening. And if you feel like, wait, what? All right, video will be available because I've already thought like I actually want to roll that back and listen to what you just said about something. So let's talk about some of these concerns and jump into the Q&A, and anyone else that has Q, we will get to your A. So will rescheduling open up more trademark opportunities for cannabis operators? I'll start with you, Luke.
In theory, yes, but maybe not in the way that the current industry would like. What I think the trademark opportunities that will be created potentially are for names of new pharmaceutical drugs, are for maybe pharmaceutical industries that would be cannabis focused or cannabinoid realistically focused. So that's not.
Yeah, it's definitely a concern about
So
also just rejection, right? Because they're not, Delta 9 is not GRAS approved as an ingredient. And if it's not an ingredient, it's not FDA compliant, it's a drug.
problems that we're seeing changing right now with trademarks, right? There's a question of all because after hemp was legalized, there's a mad rush of registering trademarks as it was related to hemp products. Are those going to be valid anymore? Or is it going to be this, okay, this one is, this one isn't, if after November, hemp products become illegal again in many senses. So are we going to see more registrations for medical goods that are cannabis related, or maybe goods that are an application cater for medical cannabis? I think there's a possibility of that because the door opens in a way, going back to the lawful use requirement. After the lawful use requirement is redefined for medical cannabis, anything that is now federally lawful would qualify for trademark protection. So that's where we're going to see opportunity. That does not necessarily mean, in my opinion, a lot for current operators. And I think in the most part, for at least how this is being discussed, it's going to look a lot more pharmaceutical model. We're in trademark registration, there's 45 different classes. It's called the NICE classification system. Class 5 has been a class you just can't register into for the most part, even with hemp-related goods, because it's the medical goods class. I suspect after rescheduling, that's where we're going to see a surge in registrations, so long as businesses choose to start creating federally lawful medical cannabis, however that looks after rescheduling.
So class 5 is what we're going to see probably go.
Right, which is
Yeah.
going to be interesting because some of the notes that I saw from doing research to prepare for this, I mean, to qualify for that $500 annual, hemp-derived cannabinoid products, it can't be inhaled, it can't be an extract, it can't be vaporized, it cannot contain cannabinoids that are not naturally occurring in the plant. So what that is going to look like is a big question mark to me, because as we've been talking about GRAS, currently you're having federal trademark applications for foodstuffs that contain THC derived from hemp and not even necessarily CBD be rejected because THC is not GRAS. So how this needle is going to get thread between all those issues, very curious to see what that language looks like and how do you identify that this is a proper medical good, not a foodstuff, not a supplement, is still a massive question mark.
One thing I would point out there is that, and we saw this with California legalization, and I think we also saw it in the Farm Bill. The people who write these laws and these regulations don't know the industry very well. And so even when they have good intentions, they're going to have really meaningless or wrong definitions of things. They will be addressing concerns that are minor while leaving out concerns that should be more significant. And so we can't expect, even with good intentions from the legislature or from government agencies that make rules, as the less experience they have with these medicines and with this industry, the more likely it is that they're going to write things that are going to need a lot of work and need a lot of revision. And in fact, that's why they've revisited this whole issue of hemp-derived products, because of the way that the 2018 Farm Bill was written. And so we're going to see, maybe we'll see some good steps forward, but we'll probably see a few steps backward and a few steps sideways as people figure out how to write good laws for an industry that they are barely beginning to understand.
Yeah, and we're accustomed to that. We're just not accustomed to all the federal agencies paying attention. They've been told to ignore this entire time. So, and then two other just quick mentions before I go to the next question is there's definitely a IP play with respect to candy companies, and candy companies are not happy at all of the copycats, and they are fully ready to convince lawmakers that it is just simply dangerous to not know the difference between a harmless candy and a dangerous drug. So let's just ban them all.
Yeah,
Please know that
I would
that's
to highlight that, and this goes for both current operators, and this is something that is not even going to be in the periphery of the medical cannabis stuff, because they're going to, in my opinion, with the amount of money that would be spent to generate a new drug, they're not going to mess around like this. But it's any of the borrowing that the culture has done from predominant culture childhoods of intellectual property assets that are harken back to your childhood or were childlike goods. There's been a massive problem with that. So, and I'm saying this in the lens of borrowing existing brands or trademarks from established candy manufacturers, or making edibles in shapes and packaging that look similar to existing candies or child associated products. And that the candy industry started lobbying directly against cannabis, especially just ranging from the use of, as I said, packaging, sometimes even just buying existing candy and spraying it with cannabinoids as a cheap way to make edibles. And then also even the idea of naming cultivars after popular existing candies. All those things have been immensely problematic and definitely should be avoided.
Yeah, it's not helping where candy companies might have just left us alone. Now they're actively fighting against us, along with liquor companies and pharmaceutical companies, which we're about to talk about. Just the overall concept is you can add food to drugs, but you cannot add drugs to food. And we are about to interpret something that was banned entirely as now a Schedule III drug. And so US food law is going to frown upon, and there's no getting around US food laws.
Right. I like as a crystal ball statement, I don't want to sound a little fatalistic here, but I would be tracking if I owned an edible manufacturing company, I would be tracking this stuff very closely because this could, of the different license types or participants in the legal cannabis industry, I think edible manufacturers are most significantly at risk of having like an entire business model get disrupted. So I would encourage, if you're listening and you have a relationship to that issue, pay close attention to this, because in theory, for what we're seeing already of the hemp food ban and the identification that, added cannabinoids even derived from hemp are not GRAS, that might start extending more after we have the FDA in charge of cannabis medicine. So.
You're muted, Dale.
Will rescheduling create more competition from pharmaceutical companies? And maybe what can we do about it?
Yeah, I think what it will do is it's going to create a category that the pharmaceutical companies will rush into, or maybe not rush. Maybe they'll just dip their toe in it. I don't want to be entirely conspiracy theory based about pharmaceutical companies, but I don't think it's all conspiracy theories either. That they like their profit margins on things they're already making. And naturally produced products just don't offer the same profit margins. And so I think they will, when they see an opportunity for kind of a traditional drug that is based on a cannabinoid, they'll explore it. They're probably already exploring it. And Schedule 3 will probably make it easier for them to do that. But I don't think they're going to be leading the way with pursuing whole plant medicines ever. And just as an interesting aside, I can't verify this from personal experience, although I'll be in Germany next week. But one of my colleagues told me that when you go into a pharmacy in Germany with a prescription for like a single molecule drug, for a traditional pharmaceutical drug, the pharmacist is supposed to encourage you to try something natural first, and to suggest a natural remedy first. So I don't know if that's true. It probably is a way for state-funded medicine to save some money, but it's fascinating, and it certainly shows the contrast between different systems.
Very empathetic.
Now that
Yeah.
is fascinating, and it's actually aligned with what I believe the current department under JFK Jr. F. Kennedy Jr. I can't get his name right suddenly. Is trying to do is to recognize and allow for more like whole plant, botanical, and such. So that would be an interesting model to move towards. And they're already, just a friendly reminder, THC is already Schedule 3. It's the synthetic THC utilized in Marinol. We also have other already FDA approved products like Epidiolex, Sativex, and Marinol dronabinol, which is the 100% pure THC. I will note that the producers of dronabinol, Marinol, did lobby the FDA to allow them to grow and extract THC because it was cheaper than synthesizing it. Fun fact. If a pharmaceutical company proves medical efficacy of a cannabinoid or formulation in my product, can I use that in my marketing?
No.
No, but the FDA said it's
Yep.
medicine and it'll have all these effects on this particular disease or symptoms. Why can't I put that on my medical cannabis product?
This is going to be a massive headache, is like
Yes.
the shortest answer for this, because if this moves forward and we do hit a point where we can point to cannabinoids where they've been granted FDA approval that says, yes, this does this. The industry itself, if you're like, well, I'm selling cultivars or I've been breeding cultivars that are very high in that cannabinoid, I should be able to start doing this. That's not the blanket effect of what an FDA approval for one specific drug, very specific way, even if the highlight is it contains a large amount of this cannabinoid, which is similar to what you're doing, those are still completely different things. And that, I think, inevitably, if rescheduling occurs and we start to see these things shape up in this way, we're going to have a huge cultural side issue of this. And I'm curious where we'll see enforcement and penalties come in with this, because we already see some FDA action around advertising CBD products as, hey, CBD helps with this or has efficiency with this issue, and then seeing cease and desist letters go out or having action taken against some CBD companies if they've made too bold of claims. So I think that only gets more confusing if we do have a rescheduling, and then we have the state programs who are like, well, okay, I guess we're selling a similar product. So I think that if this moves forward for current operators, pushing state agencies to have clarification about what that interaction is going to be would be in the interest of the industry. And because people inadvertently, I mean, having the collective around language about what this product includes is going to only become more problematic. That's how I see this shaking out.
If a cannabinoid is patented by a pharmaceutical company, does that specific cannabinoid ingredient become a drug and therefore not allowed in the food supply, such as cannabis edibles and beverages?
There are two angles on this, and I think the patenting wouldn't really be the problem. I think it would be more the FDA regulatory approval of the cannabinoid. So let's suppose that the FDA approves a cannabinoid in a drug. And then they may try to regulate, they may just say, well, since this is a drug, we're going to regulate every use of this in all forms. But it wouldn't really be the patenting. And one thing I think people worry about this a lot, and it's good to ease people's minds when you can, because it's so rare that you can ease people's minds. You cannot patent a natural product. You can't, if something is a product of nature, you can't patent it. Now, you might be able to patent it in a form that never existed in nature, like in a purified form. That's possible, but even then, with conventional cannabinoids, those have been purified for a long time, and so it would be, in order to for anything to qualify as a patent, it has to be considered new and made by the hand of human activity. So if it's a natural product, it's just not going to be patentable. So I don't think that would really be the issue here. I could explain at greater length, but in the interest of time, I'll just stop there.
So how will rescheduling impact cannabis patents?
I think it will affect the profile of who is applying for what kinds of patents, but um, because on the patent side, as explained earlier in the seminar, there's never been a legality requirement to qualify for a patent. And even as cannabis was considered highly illegal, it didn't affect the eligibility for patenting cannabis-related products. And so I don't think that rescheduling is going to have an impact on patent eligibility, but it certainly could have an impact on who applies for patents on what kinds of cannabis products.
And it's the classification number 5, which has been closed to us.
That's trademarks, not patents.
Sorry, trademarks. See, patents v. trademarks. Thank you.
Mm-hmm.
Different. Oh,
That's why we're both here.
that's
Yep.
why you're both here. And
Yep.
I only play a lawyer on TV. I am not one, nor am I a patent attorney. All right. So the categories of inventions and the types of clients, that will be the game changer. Yeah.
Yep.
And I think in both categories too. All right. Does rescheduling affect hemp IP in any way?
I think, I mean, depending on the language, creates new opportunity for hemp-related drugs. So from the trademark sense, yes. And we're going to see some of the trademarks phase out, arguably, and being lawful or enforceable after November. So, I mean, that's independent of rescheduling, but yeah, I think if we do see rescheduling, there would be new opportunities, very limited, for hemp-related medicine.
In
Yeah,
pharmaceutical, go ahead, Dale.
go ahead. I was just going to say, I don't see a big effect on the patent side for him.
Can pharmaceutical companies obtain utility patents for cannabis medicines?
They can, if anybody, look, we'll put it this way, and this might sound flippant, but it's intended to convey the way the law is. Anybody can qualify for a patent if the thing they're seeking a patent for is new, not obvious, adequately described, and eligible for patent, meaning it's not a product of nature or a mathematical formula or something like that. So they definitely can get a utility patent on a cannabis medicine if it's new and if it's not obvious. And I'll just elaborate on that a little bit more. When I've had lots of clients file formulation patents, and the most predictable thing in the whole patent world is that anytime you have a formulation, which is a combination of ingredients, the examiner is going to reject it as being obvious because they'll say these things have been around for a long time. Of course, people would try any combination of ingredients. And the way to overcome that, though, and it's slam dunk if you have this evidence, and it's really hard if you don't. If you have evidence that this particular combination gives you some unexpected results, then that is a complete rebuttal to an obviousness rejection. And so I always tell my clients, let's look at your evidence of unexpected results. Are these ingredients synergistic somehow? And if so, then the patent's going to be, you're going to be able to overcome that obviousness rejection. And that's really what you'd see here if you applied for utility patent on a cannabis medicine is, do you have an unexpected result, whoever the applicant is?
So should operators be worried about new cultivar patents?
No, that's in general, a new cultivar patent is narrow. It's limited only to that cultivar. It doesn't even reach out to be similar cultivars that aren't genetically related. And so, if I breed a certain plant variety and I know that I was the one that developed it, and someone else has a patent on a different plant variety, those patents are going to be great to protect against direct copying if someone gains access to your genetics. But similarity alone is not going to constitute patent infringement. Now, there are some exceptions to that with you if someone gets a utility patent on a plant cultivar, but those are really rare, and even those, the valid ones, are quite narrow. So I would just say that's very far down your list of things to worry about.
Should manufacturers patent their original formulations now?
Well, the way I'll answer that one is that if you're a patent attorney, I go back to the thing, the saying, if you're a hammer, everything looks like a nail. Patent attorneys are always in favor of you patenting the things that might be patent eligible. But I think that the real question is, first of all, make sure it's patent eligible, and then make sure that what you think is the likely life likely value of that invention over the course of a 20-year patent term is going to be many X the cost of getting a patent. Getting a patent does not make it rain money. It's just the beginning of an opportunity to protect the value of something. And if it has questionable value in the first place, getting a patent is not likely to add a lot of value to it. It's really the marketing and the quality of that product that creates the value, and the patent protects the value.
Okay, so let's briefly discuss rescheduling versus descheduling, which means taking it out of the Controlled Substances Act, and then you can still go through the FDA process with any one of these constituents. So it's not in any way, shape, or form blocking what pharmaceutical companies could do, but it does, change the way everything else gets interpreted. So we are going into a whole nother level of uncertainty and unnecessary ridiculousness by rescheduling instead of descheduling. And I don't think it's paranoia. I think it's a healthy concern for the truth that pharmaceutical companies are lobbying to keep what we do as illegal as possible while they pursue their formulations and opportunities with what will certainly be a multi-billion-dollar annual industry for them. So what can you do? You do have a voice, you do have a vote, especially with, and only really with those that you vote for, meaning if you are not in someone's district, the only way you get their attention is with money. So lobbying for yourself, not as a registered lobbyist, but what you do to represent yourself and your company while you set yourself up for success, prepare for the worst so that you are able to navigate. And I heard both of you say at the top, this is not a time to go make big changes, big decisions, big investments. This is maybe a time to hibernate, maybe hold on some of the ideas and expansions that you might have in mind, and start to build your resources towards this next moment. So let's talk about how to do that. 2 regulatory pathways: the botanical cannabis regulated potentially as a supplement, which is a whole nother can of worms, supplements and how those are being treated. But I do understand that is also another path being pursued by some individuals, and medicines that require FDA approval. Let's unpack this just a little bit on any last thoughts of Luke, Dale, what you feel folks should really be advocating for.
I think current operators should be affirming with the state that they're operating in that the state programs are going to continue no matter what. No matter what rescheduling does, we voted to have recreational cannabis or adult use cannabis in these states. And a significant amount of money has been spent to allow people to operate. Clearly, people have spoken and said, hey, this is what we want. I think, as much as it sounds kind of ridiculous, a little bit of reaffirming with the state agencies and the state itself and saying, hey, we're going to continue this, right? Because in a worst case scenario, I think if bigger money industries really get involved, having them try to box out current operators or just say, well, actually what this means is we get this much of the market, or, oh, this thing that you've been doing, it's actually going to cause confusion around this new drug that I want to sell. I'm willing to spend money to try and squash what you've been doing. So I think reminding the state that this was voted into, there's a legal right to move forward. It's beneficial. It gives people jobs. All because if rescheduling occurs, in my opinion, we're going to be there's a new different fight to try and get to rescheduling. So if we end up in this kind of intermediate phase of medical and the existing programs we have, I just want to make sure that we get to continue doing what we're doing and we don't see this like, oh, it's rescheduled. Well, we should revisit all these state rights. Maybe that wasn't done right. So I know that sounds a little bit like a sky is falling statement, which I don't mean it to, but I've just found in cannabis, oftentimes preparing for the worst and then hoping for the best is more of a logical way to approach things than just say, oh, I'm sure we get to coexist with this new FDA oversight and pharmaceutical companies potentially coming on the scene. I'm sure everybody's just going to exist in a very copacetic way. I don't have a lot of faith in that.
Yeah, and state and local governments have an investment at this point and a responsibility, a duty of care to the small and larger businesses that have been part of their tax base, been part of the solution, been operating legitimately and doing everything right, that now we need to demand that those state and local governments stand up and not only defend our right to continue, but demand that we're able to do business without unfair taxation and with some semblance of safety, that we're not going to be selectively prosecuted for doing the right thing this entire time. But it is going to take state governments advocating and demanding for these interpretations from the federal government in order for that to happen. Dale?
Yeah, I think the only other thing I would add to this, and I'm not even adding, I guess I'm just emphasizing because we've touched on this, and that is that this is a time to educate the people who are making the policies and to get pretty specific. I'll give one example. My mom is pushing 90 and she was managing all kinds of extreme pain with opioids. And finally, her doctor convinced her to try CBD. And she so when she was on opioids, she would fall every few months and break more bones and be in the hospital longer. And my sister was convinced that's how my mom was going to die. When she switched to cannabinoids, when she switched to CBD for pain management, she hasn't fallen once in 4 years. And she's so much more alert. She's so much more cognitively herself that it's like a new lease on life. So that's a nice story. But if you think about the impact on, she's on Medicare, she's got some resources, but she's old enough that obviously she's getting some state reimbursement. The cost of her, the cost savings from her not being hospitalized every few months and from not having to provide all kinds of home care and everything is so practical. It's so beneficial to the public that switching her off of opioids onto cannabinoids benefits the entire state that she lives in. And I think if we learn more things like that and educate our policymakers about things like that, that we might begin to be able to counterbalance the strong lobbying power of the pharmaceutical companies that want everybody to be on these more expensive and less beneficial drugs.
And I believe in America, we can and do regularly walk and chew gum at the same time. And so while the one regulatory pathway for isolates, in effect, that's what the FDA loves, is single compounds. That's why we have compound pharmacies, so that somebody else can mix it together, and then you still only have two. And we've talked about the hundreds of chemicals in cannabis, just like there are hundreds of chemicals in apples, and they are good for you. And so we just really have an opportunity to deschedule botanical cannabis. And that is something we can continue to push for, and one that we can potentially partner with the hemp industries now that they are also facing an existential threat, that this is one plant and it's going to take all of us together asking for the same thing. And very specifically in the state that we live in, to ensure that the state is also reducing some of the regulatory load and costs on the state legal cannabis businesses, because this is also a cost issue, not just for the businesses, but for the purchasers, the customers, the end users, whether they count themselves as patients with Schedule III prescription, or it's, Aunt Betty going to the local dispensary, and which one? Is it the licensed one or not? And that is the decision that every customer and consumer doesn't understand that they are making, that they are putting their money where their morals are, and how to also convince your friends and family to continue to advocate for this as well. And on your level, in addition to asking to deschedule botanical cannabis at the same time that we talk about all this rescheduling, go ahead, jump through all your hoops. Let's focus on descheduling botanical cannabis, so that, let's let the artificially created cannabinoids remain in the FDA, and we do the whole plant medicine and state legal businesses. And also just make sure you're lobbying for GRAS cannabinoids. That's generally recognized as safe. That means you can eat it as a food. Non-psychotropic cannabinoids should be considered GRAS in appropriate doses. Danger's always in the dose, but we have yet to find the lethal dose for any of these cannabinoids. And we all know that friend that has tried, right? And last, prove prior use. Make sure that you, as an operator, as a manufacturer, that you are documenting your formulas and your methodologies before they are challenged. You need that date time stamp that you were there and you did it first, so that you can protect your formulations. Anything you want to add to that before I close this out?
Oh, great.
Fantastic.
you.
And for those of you still with us, please access your LMS system. And if it is the first time you're trying to do it, you can visit tinyurl.com/DCRLMS. And then you can just log in using the email address that is linked to your DCR Acela account. And then you can use that temporary password 1, the number 1, after your initial login. The system will then have you create a new password that you can use moving forward. And as always, you can ask for help with our friendly folks over at dcr.sep@lacity.org if you need to email them. All right. And with that, I just want to thank each and every one of you, especially you, Luke Zimmerman, and you, Dr. Dale Hunt, for being a part of today's webinar. This was so informative. And thank you again to the Department of Cannabis Regulation, DCR, for this important program, the BLC program. My name is Dale Sky Jones. Thank you so much for joining me today. And I hope you have a wonderful rest of your day and an even better week. Thank you.